Sharon Gingerich and myself, Geauga County Probate Court Judge Tim Grendell. We welcome you to the Geauga County Probate Court and tonight's Good Deeds program. The Good Deeds program is a simple program. Its goal is to help give you the tools so that you can take action now to save your family's time and money when the time comes because someone passes on. We have a Good Deeds checklist. I hope everybody has a copy of the Good Deeds checklist because I will be going through this. There will be no test at the end of the day. And for those who might be watching this, and we thank our friends from GTV for sending this into homes, they can get a free copy of the Good Deeds checklist, and I stress the words free, by calling the Geauga County Probate Court at 440-279-1840 and asking for Cheryl, or calling Sharon's office, and she can get you one as well. But it would help if you had a copy of the checklist to save the time and money that we're going to talk about tonight. The Good Deeds program has one simple premise, and that is that how you own your property while you're living will decide what happens to your property when you pass away. There are two types of properties in Ohio. There are probate assets and non-probate assets. If your assets are non-probate assets, they don't transfer through this court, and when someone passes on, they don't have to go through the time and expense of going through the probate court process. If your assets are probate assets, the only way you can transfer a probate asset is through this court, and it's either pursuant to your will or pursuant to the state statute of descent and distribution. So the purpose of the Good Deeds program is simply this: to teach you how to turn all your assets into non-probate assets so you can avoid having to come to this court, and your family members can avoid the time and expense of coming to this court when somebody passes on. So we will begin with the checklist, if you have the checklist this evening. If you're like my wife Diane and I, your single most valuable asset is your house. Now, if you've owned your house for a while, you probably have a deed that says your name as the grantee and your heirs and assigns. If that's what your deed is reading, your home is a probate asset because that's a tenants in common ownership and can only be transferred through the probate court. So if my wife and I own our house, and when we got it, the deed said from the people who sold it to us to Diane and Tim Grendell, heirs and assigns, and I pass away this evening, my wife is going to have to file with this court to transfer my half interest in the house to her. It's going to take time and it's going to take money, and the reason why it takes time and money is the state legislature dictates the procedures we have to follow in the probate court process. And they also tell us what we have to charge for fees. And we don't have an option. Those are set by state law, both as to time and to fees. And even though there are some summary things we can do to speed up the process, it still will take several months to transfer a half interest in the house or a whole interest in the house to the heirs of somebody who passes away. So how do we avoid that problem? You have two ways of avoiding having to come to this court to transfer real estate. Number one, if you own your real estate in joint and survivorship with another person, when the first person dies, the second person doesn't have to come to our court to transfer title. Instead, they take a copy of the joint and survivorship deed and a certified copy of the death certificate, and they go downstairs and visit with Sharon. And for $28 for the first 2 pages and $8 for a page thereafter, it transfers in a day downstairs versus months up here in the probate court. So if you own your property with another person, for example, husband and wife, if your deed is a survivorship deed, when one of you passes away, you can transfer the interest of the person who passed away to the surviving spouse, not through this court, but through Sharon's office downstairs. How do you do that? Well, what you do is you actually prepare a new deed from you and your spouse to you and your spouse. And instead of having the heirs and the signs language that was in your old deed, you have language that says to you and your spouse and the survivor thereof. When you add that magic language, you transfer your deed into a non-probate asset, and you make it a survivorship deed that allows you to go downstairs and move the property quickly instead of going through the probate court process. Now, for those of you who are here this evening, you have a couple of choices. And for those at home, you can go see your family lawyer and tell them you need a joint and survivorship deed. You can tonight see some of the volunteer lawyers we have today, and we have Robin Stanley, we have Richard Ivins, we have Michael Wagner, and we have James Smolinski here tonight. So when I get finished speaking and Sharon gets finished speaking, you can meet with one of them, and they will meet with you to talk about your personal individual situation. They have a special rate for deeds. I believe it's $100 plus filing fees, and you can have them do it for you. You can contact the Bar Association, and they have a lawyer referral system. If you don't have a family lawyer, and you don't want to talk to a lawyer this evening, you can contact the Geauga County Bar, and they will provide you a lawyer referral. And if you're over 60 years old and live in Geauga County, you can get legal services through the Department of Aging. It used to be 3 hours a year for free. Now it's 3 hours a year. I believe there's a $25 per hour fee, but you can still, that's still cheaper than a lot of other folks. And you can do that going through the Department of Aging. But you have to call the Department of Aging and schedule an appointment. You can't just show up and say, I'm here to see a lawyer. And right now they're booking people 2 to 3 months out. So as you'll see here this evening, the things we talk about are things you have to be able to do and you have to be able to sign. So if you're going to get an appointment 2 to 3 months out, you got to stay healthy to make this work, okay? So your options are your family lawyer, the lawyers here this evening, the lawyers through the Bar Association, or if you're over 60, you can schedule an appointment at a reduced rate through the Department of Aging. And they will help you prepare a deed from yourself and your spouse to yourself and your spouse. Now I say this, one night we were doing this, we've been doing this for 6 years. One night Sharon and I were doing this and I made the comment, how do you do this? You do a deed from yourselves to yourselves. And 2 weeks later there was a deed in Sharon's office from ourselves to ourselves. Pronouns don't work. You got to use your names, and that may be a reason why you can do this yourself if you'd like to try, but if you get it wrong, it's not going to work. So it may be worth talking to a lawyer for a nominal sum to get the paperwork right. But if you do this, it has to be properly done for Sharon to be able to record it. Now, joint and survivorship deeds are not a one-shoe-fits-all situation. We did this the first night in South Russell, and there was a gentleman there in his late 70s. And afterwards he came up to me and said, Judge, after my wife passed away, I decided to put my 27-year-old daughter on my deed, joint and survivor, so that when I died, it'd make it easier for her to transfer the property. And 6 months later, my daughter's husband filed for divorce and put a claim on my property because she was now part owner of the property. So the warning there is if you add somebody jointly to your property, you bring with them their baggage, their creditors, and their potential problems. So if you're going to go into a joint and survivorship situation, A, you need to really trust the person you have on there. For most of us who are married, especially after a while, that's probably a safe bet. But second, you have to make sure that you want those people to bring their risk to your property. That's why you should talk to your family lawyer, one of the lawyers here this evening, or a lawyer through the Department of Aging or the Bar Association to make sure joint and survivor fits your situation. As another example, if you're in a second marriage and you want to leave your interest in your house to the children from your first marriage, and you put in your will, I leave my house to my children from my name by name of the first marriage, and then you enter into a joint and survivorship deed with your current spouse, when you pass away, your property is going to your current spouse, and those children from the first marriage will get nothing. Because the joint and survivorship deed removes the property from the probate process and therefore removes it from the will. And so those are the kind of things that probably, if you're especially having changed in your life over time, you should discuss these things with your attorney to make sure that joint and survivor works for you. What if you don't want to add somebody onto your property? Well, then there's something called a transfer on death affidavit. That's the second way you can convert a probatable interest in real estate into a non-probatable. You fill out a transfer on death affidavit, which means you own the property to the day you die. But you say, upon my death, I want the property to go to Sharon. And when I pass away, Sharon doesn't have to come to probate court to get the interest in the property. While I'm living, Sharon has no interest in the property, so her creditors and her problems are not my problems. But once I pass away, she takes that transfer on death affidavit and a certified copy of my death certificate, plus another affidavit, and comes down and visits her, and for $28 for the first 2 pages and $8 for each page thereafter, she transfers the property in one day instead of going through probate court. So you have two choices. You can convert your property to joint and survivor, but be careful who you add to your property, or you can go with transfer on death affidavit, and you can, in either event, when you pass away, your interest in real estate will not come through this court, will not take months to transfer, will not cost hundreds or thousands of dollars, but rather will transfer in a day in the county recorder's office. The people here tonight, any lawyer around that you can talk to, your own lawyer, the Bar Association, the lawyers tonight, they're all prepared to help you with either joint and survivorship deeds or transfer on death affidavits. They both have to be recorded in Sharon's office for them to be viable long term. So I would talk about, if you want to protect your real estate from the probate process, talk to your lawyer or the lawyers here this evening about either a joint and survivorship deed or a transfer on death affidavit. I will add this: the first night we were in South Russell, at the end of the presentation, this nice 90-some-year-old farmer came up to me and he handed me his deed, and he said, "Judge, my wife and I have owned this property for over 50 years. And I looked at the deed and I said, "Well, you're half right. Your wife's owned it for 50 years. Her name doesn't even appear on the deed." I'm surprised we still had a farmer standing there 5 minutes later. And I'm glad to say he made it through the night. But there was a lesson there. If you're like Diane and I, when we bought our house, the deed came back from a title company or a bank. We stuck it in that drawer with all our wonderful, precious documents that we want to make sure we can find, and we never looked at them again. So if nothing else during this exercise, you may want to look at your deeds and make sure they are in your name. You may want to look at your paperwork and make sure you own what you think you own, and then talk to lawyers about how you possibly can transfer it. I said before about the Department of Aging and the time delay to get an appointment, but you'll save money. We were doing this presentation in Auburn about 3 years ago, and there was a very nice lady sitting in the front row. She was in her 80s, and while I was talking like this, she handed me her deed and said, "Judge, what do you think?" And I took it and I said, "Well, I'll use this as a teaching tool." I looked at it, I said, "I think you have a tenants in common deed. If you or your husband pass away, you're going to have to come to probate court to transfer the property." And I gave it back to her. And she said, I started talking again, and she says, "Does it matter?" And I said, "Does what matter?" And she says, "Does it matter that my husband passed away last week?" And I said, "Oh, yes, ma'am. I'm so sorry, first of all, for your loss. But second of all, he needed to be here to be able to sign something to make this work." And then I went on to talk some more, and then she said, "Well, I'm just not going to do anything." And I stopped again, and I said, "Ma'am, I can understand your frustration." I said, "But I assume that's your daughter sitting next to you." I said, "If you do nothing, when you pass away, your daughter's going to have to first open up an estate for her deceased father to transfer his half interest in the property to you, and then open up an estate for you to transfer the whole interest in the property to her." I said, "You might want to talk to one of the lawyers about cleaning this up and saving her that time and expense later on." And that's what the lady did. But the moral of the story is twofold. Remember what I said at the beginning: how you own your property while you're living will decide what happens when you pass away. Now is the time while you're living to make the changes to avoid the probate process, and you have to be able to sign things to make that happen. So if you're going to go with the Department of Aging again, that delay could come back and be an issue, but it's something that you have to weigh versus the cost savings going with the Department of Aging. Now, we talked about real estate. Let's talk about some of the other aspects here as well. Bank accounts. we see a lot of estates here for bank accounts with $300 in them, $800 in them, $1,200 in them. And there's no reason why a bank account should ever have to go through the probate process. When you open up your bank account, or if you have an open bank account, you should be able to designate what happens to your money when you pass away between you and the bank. For example, you can make somebody a joint and survivor owner of your bank account. And what that means is if you add me to your bank account and you pass away next week, all I have to do is go to the bank with a certified copy of your death certificate to the bank, and the bank will transfer the money to me as the joint and survivor designee on the account. No probate court involved. However, remember, when you add somebody jointly to anything you own, you make them co-owners. So if you add somebody jointly to your bank account with $1,000 in it, you have given them co-ownership of your $1,000, and they can spend it while you're living, and you don't have any recourse. So you want to be careful about who you add jointly to anything, let alone jointly to your bank accounts. How do you still avoid probate without having that risk of joint ownership? Well, the answer is very simply this. You go to the bank and tell them you want to have a payable on death designee on your bank account. And what that means is the bank has you fill it out. For us old timers, it used to be a little card. Now most of the stuff is done in the computer. But you say, it's my money till I die, and nobody can touch it but me. But when I die, I want it payable on death to Tara. And then I pass away, and Tara takes a certified copy of the death certificate to the bank, not the court, and gets the money through the bank without ever going through the probate process. So on your real estate, you can do joint and survivor, transfer on death. Your bank accounts, you can do joint and survivor, but be careful. But you can do payable on death and therefore avoid the probate court process. Why the banks don't explain this to the people more often, I'm not quite sure. But there's no reason for us to have to open up estates here to transfer, a relatively small amount of money. It costs several $100s just to file to open, and then, they're barely getting enough money back for the filing fee. But the bank will not give you the money if it's in somebody's name and that person has passed away and it's not joint and survivor or payable on death. What about motor vehicles? Well, if you're married, the law in Ohio has changed. It used to be a surviving spouse could transfer 2 vehicles up to a total value of $40,000 without going through the probate court. This is for married people only. They changed the law last year. Now it's an unlimited number of vehicles can be transferred from a deceased spouse to a surviving spouse up to $65,000 in value. So if your husband passes away and he had in his name only 2 cars and they're under $65,000 in value, you don't have to come to visit us here to transfer the cars. You take a certified copy of the death certificate, and in this case you go to the clerk of court's auto title department at 470 Street, and they will transfer the cars for surviving spouses. Unlimited number of cars up to $65,000 in value. If your surviving spouse is driving a Maserati, this will not help you. But anything short of that, you should be able to do something like that. Now, how else can you avoid the problem, and what can you do if it's not a surviving spouse? Like it's your children, and they're single, and they're 18, they're 19. Well, you can have something called a transfer on death on your car title. We have 2 examples here. One example is with John Doe in his name only, and if John passes away and he's not married, somebody's coming to probate court to get that title transferred to that car. However, if John Doe TODs on the title, transfer on death, just like we talked about with real estate, on the title TOD, and John Doe passes away, in this case, Mary Doe takes a certified copy of the death certificate to the clerk of court's auto title department at 470 Street, at the 470 building, and transfers it there in one day versus going through the probate court process. So for spouses, unlimited cars up to $65,000. If you have really expensive cars, you may want to put your spouse TOD on the car title or jointly owned on the car title with survivorship. For other people, if you're not married, you need to do TOD if you wish to avoid the probate process to transfer cars. Where does this come up in this court in the last 3 years? Unfortunately, it is a byproduct of the heroin problem. We have had more 18 to 30-year-old single people pass away from heroin than I would like to remember, and their parents come here after the agony of losing a child to have to transfer the child's car. And because it was not transfer on death on the title, they've had to go through a limited probate court process to get the car. How can you fix this, by the way? Just go to 470th Street to the clerk auto title department, and for $19, I believe, is the current fee, they will add somebody TOD to your current auto title. So you can add somebody today if you're worried about that. I would wish that the car dealers would tell you this, because when you buy the car, you can do this for no additional cost. You just add somebody TOD to the title. The beauty of TOD is the TOD designated person has no rights to the car while you're living. The beauty of TOD on real estate is the same thing. The TOD designated beneficiary has no rights to the real estate while you're living. It only kicks in upon death, just like a payable on death account. So you can put this paperwork in motion, and it'll take care of itself when the time comes, but it doesn't interfere with your current ownership of the property. When you add somebody jointly to your property, there is some co-ownership issues that then come into play. What about other things? Boats, campers, RVs, and mobile homes that aren't affixed to the ground are all transferable by title, and therefore you can add a TOD notation on the title to avoid the probate court. So if you have your boat, your camper, your RV, and even your mobile home, you can have on your certificate of title transfer on death to another person and avoid the need to come to probate court to transfer. And again, that's not through this. The transfer and death, the TOD notation goes through auto title, does not go through the probate court. How about stocks, bonds, all these things, CDs, life insurance, annuities, investments? None of these ever have to come through this court if you do your paperwork right. And for example, stocks and bonds. Talk to your stockbroker. You can have payable on death transferees on your stock. You can have transfer on death designees on your stock. What that means is when you pass away, the stock will be then transferred to the person you designate when they show up with a certified copy of the death certificate, versus coming through the probate process to transfer that stock. These are between you and your stock and the companies that issue your stock. Talk to your stockbrokers. They can help you with that. Life insurance is a particular annoyance around here. We get estates open up for life insurance policies for $300, for $10,000, and these are life insurance policies where no beneficiary has been named. So it's just nobody there. The policy's just for the person, but they didn't designate somebody, or the person they designated has passed away. So if you have a life insurance policy to your son or daughter and they predecease you, when you pass away, if there's no alternative or contingent beneficiary named, whoever's going to inherit from your estate has to come through the probate court to transfer the property. So how do you avoid this? It's really simple. You make sure if you have life insurance, you have a beneficiary designated. And you can have a contingent beneficiary designated in case the first beneficiary has passed away. And you can have a contingent beneficiary designated just to make sure you've covered all your bases. And should you lose one of your beneficiaries, it still gets distributed by the insurance company to who you designated without coming through the probate court. It's amazing to us, though, that we will get these small insurance policies where there either is no beneficiary designated or the beneficiary has passed away, and then we have to go through a probate process just to transfer a relatively small amount of money. All this is avoidable if you take a couple hours, take the checklist, talk to your financial advisor, your stockbroker, your lawyer, one of the lawyers here this evening. If you go through this checklist and take the actions that this lays out, then the likelihood that your family will have to come here to transfer property will be extremely remote, because it's not going to be probate property. And again, there's variations and options that you have. You should talk about it with your lawyer, your family lawyer, or the lawyer that you discuss with this. Now, having said all that, if you really want to be fancy and you want to avoid coming to the probate court, you can create a family trust. And you create a family trust and make yourself the trustee and yourself and your spouse the beneficiaries. And you can designate upon the passing of yourself and your spouse who's going to take over the trust and who's going to be the beneficiaries after that, normally your children or your grandchildren. And what happens is when you pass away, the trust does not die. The trust is an entity and it continues. And so there's nothing to come to probate court for because everything you own is in the trust and the trust continues to operate per your trust document. That's pretty fancy stuff. But if you want to do that, you should talk to a lawyer who knows what they're doing with trust work and get the right trust paperwork for your particular family needs. But there are a couple benefits for having a family trust. One is the assets transfer without coming through this court. Two is, if you got nosy neighbors, they'll never know what you are worth. But if your estate gets filed with our court, the first thing that happens after an estate is opened is somebody has to file an inventory and accounting of everything you own and what it's worth. And everything dealing with an estate is public record. So if you had nosy neighbors who really want to know how rich you were, they can figure it out by coming to the court. Whereas the trust is not filed with the court. We don't know what transfers through the trust, and that's private. Last but not least, if you want to control your property from the grave, a trust will allow you to do that. For example, if you don't want your children to spend all the money the first year after you're gone, you can put in a trust that they can only get so many dollars a year for so many years, or they can only draw down on the trust for educational reasons, or buying a house, or for medical care. The trust is your creation. You can control your money any way you want for as long as you want, relatively speaking, into your next generation, the generation after that, even the generation after that. These are the things, if you're really adventurous, you should talk to your lawyer about doing. I will give you this caveat, and I hope it doesn't apply to anybody in this room, but we've seen an awful lot of heroin issues in this court in the last couple of years. And I will tell you this, if you do have a family member who has a drug problem, it does not help them if you leave them a large amount of money that they can control themselves, because the likelihood that that money is going to go to good use is reduced by the degree of their addiction. So if you have somebody with a serious drug addiction history, you can leave it to them in trust in the name of a trustee who will make sure the money is there to help them with their needs, but not to be wasted because of their addictive habits. So that's a reason to do that. The Kennedys and the Rockefellers have figured this out a long time ago. They do the trust also for tax avoidance purposes, which is far too complicated to get into today, but also because nobody knows what the Kennedys and Rockefellers own or who even has it now, because it's all been protected by their family trust. If you're looking to do a trust, it's probably going to cost you between $3,000 and $6,000 in Geauga County to get good trust documents. But it's worth making sure if you do this that you do it right. And the other downside of a trust is you have to live as a trust. You have to sign everything as Tim Grendell trustee, not Tim Grendell, because I don't own it, the trust does. And you have to get used to filing trust things and signing trust things and living as a trust. And for a lot of people, especially people over 65, it's more headache than it seems worth to a lot of people. But it's something for you to consider if you want to go that way. Now, you've done everything we've told you to do or recommended that you do on the checklist, or you decide to create a family trust. Then the question is, do you still need a will? You should have a little card on this as well this evening. Well, you still need a will, because a will sort of works like this. In baseball, we have a catcher, but we still have a backstop because everything doesn't always get caught by the catcher. So the will serves one purpose, in that if you didn't get something, joint and survivor, transfer on death, you forgot to get somebody named as a beneficiary, then this court will have to probate that asset. And the question is, who do you want it to go to? If you leave a will, then you decide who it goes to. If you don't leave a will, and you should have this document as well, this is the statute of descent and distribution by the state legislature. When there is no will, and there's an asset that has to go through this court to be probated, this is the direction I have to follow to who gets it. Okay, so you do the will just in case you miss something, or you do the will because you don't want to do some of the things we're suggesting this evening. But without a will, your property will get distributed, your probatable property will be probated according to this chart. Now, I will tell you what happens with this. We had a gentleman here who was in his 70s, and he was an Army veteran, as I am. And his first wife passed away about 10 years before they showed up in the court. And he lived in his deceased wife owned the house in her name only. And she passed away. And he lived in the house for 10 more years and remarried. The problem was the first wife had 3 children, none of them being his. They were from her first marriage. And if you look at the chart, when somebody dies who is married but has children from a previous marriage, the current spouse basically gets 1/3 of the estate, and the children from the previous marriage get 2/3. Well, somebody must have told those 3 children 10 years later that they had an interest in that house, because they filed to probate the estate some 10 years later, because there's no statute of limitations on that. And they wanted their interest in the house. As you can imagine, the man who was living in the house with his subsequent wife wasn't thrilled about giving up the house. And they didn't want to, but I was forced to order the sale of the house and have the money distributed 1/3 to him and 2/3 to the 3 children from her first marriage. He was not happy, to put it kindly, but that's the law. And at the end of the day, this court is required to follow the law. How that could have been avoided? Well, the first wife could have done joint and survivor to the man, or transfer on death, or had a will. Any one of those 3, and we wouldn't have gone through that process. But when you don't have any of those, you follow the statute of descent and distribution. Now, a few heads up on wills. If you have a will and nobody knows where it's at, you don't have a will. Okay, if you have a will and you put it in a place that it can burn, you may not have a will. And we have people coming here every year who say, Dad had a will, and he said he was leaving this to me or him or her. And I said, great, show us the will. We don't know where it's at. Well, if you don't know where it's at, I can't make it up. It has to be physically available for us to probate the will. So if you have a will, make a photocopy. Tell somebody like your executor, that's the person you designate to handle your estate. Tell them where you put the will, or give them a photocopy of the will, because I can accept a copy under certain circumstances, but I can't accept somebody's oral representation of what some missing will said. And last but not least, if you would like, you can file your will with this court. We have safes back here to hold that are fireproof, and we are required by state law to hold people's wills filed with us. It used to be a $5 fee. The state of Ohio has changed the fee to $25. It's a one-time fee. You can file your will with us. We put it in the fireproof safe, and when you pass away, we don't probate the will. We send the will to your executor or executrix and advise them, here's the will. Not all wills get probated. If you don't have any assets to probate, or you've made all your assets non-probate assets, you don't have to probate the will. But we can keep it here, and we can make sure it's available should you need to do the will. And again, the cost is set by the state of Ohio. Last but not least, how many of you have grandchildren under the age of 18? Do any of you have children under the age of 18? Okay. The people who really need wills aren't the people who have maybe a lot of financial assets. It's the people who have the most important assets of all, which is children under the age of 18. Because here's what happens when mom and dad of children under the age of 18 pass away. Grandparents A file to be the guardian of their grandchildren. Grandparents B file to be the guardians of their grandchildren. They sit in this courtroom, and we have a rather spirited hearing where both sets of grandparents try to convince me which set should raise their grandchildren. By law, I got to pick one, not both. And so what happens is I make one set of grandparents happy and one set of grandparents hate me for life, but it's my requirement to have to get somebody to raise those children to the age of 18. But if the parents of those children, so if you got children under 18, I'm talking to you. If your grandparents who have grandchildren under 18, I'm talking to your children. If somebody who has children under the age of 18 has a will, And in that will, they designate who should be the guardian to raise their children should they as parents pass away before the children turn 18. Then that person designated in the will comes to the court and asks to be appointed guardian. And all I have to do is make sure that they're suitable to raise the children. They don't have some record for child endangerment. And then I carry out the wishes of the parents of those children. I designate that guardian as the guardian pursuant to the will. So if you have people who have children under 18, they may want to have a simple will, not because they have to transfer their fortune, but to designate who should raise their children should something happen to them. This conversation used to happen a lot more in the 50s and the 60s in the context of plane accidents where mother and fathers passed away. It still happens, unfortunately, in car accidents where mothers and fathers pass away in the same accident. But in this court, it has happened way too often when mom and dad of children under 18 have passed away from heroin overdoses. And we have had to pick the new guardians for the children because they didn't have a will. So if you care about your grandchildren or you've got children under 18, you should seriously think about talking to a lawyer about a simple will, just to name a guardian in case something happens to take care of your children. With that, what we will do is Sharon has some things to say. We'll take some questions and answers, and we've got some folks out there. And if you wish to start seeing the lawyers, because we got a pretty good sized crowd, we do have lawyers out there willing to look at your individual will.
Good evening, everybody. I want to tell you, first of all, about a letter that you may receive if you do something with your deed. And it'll come from a company that will offer to give you a copy of your deed for $89, along with some information about your property. You got it free from me tonight, or if you make it yourself, it's 10 cents a page. But they'll offer it to you for $89, and then they'll include some of the auditor's information on the RealLink site that you can get for free. Supposedly the legislature outlawed this. It was supposed to go into effect in August, but from what I hear, the letters are still going out. If you get one, I'd really appreciate it if you'd bring it to me or call the Attorney General. Okay, somewhere you have your original deed. Just want to throw that out there. I know the judge mentioned it, but look at the deed you have in your hand tonight. Is the address right? Are your names right? Middle initials and everything? Names spelled right? Are the right people on that deed? And is everybody who should be on that deed on that deed? When I do indexing every day, I often will get a deed with one person's name on the deed, and the next document will come through with two people on the mortgage. So somebody's is going to end up paying for a house they don't own because they forgot to get their name put on the deed. So you want to pay careful attention to that. Sometimes it's intentional, sometimes it's not, but it happens. Look at the legal on your deeds. Do you own more than one parcel, and did you sell one? Did you do a lot split? You want to be sure and tell the attorneys about that tonight, or whenever you go see an attorney, that information has changed so that they can put the correct information on your next deed. Remember, just because you record a survivorship deed or transfer on death doesn't mean the property transfers. After someone dies, you have to come to my office. You have to prepare an affidavit saying that someone has died. And that has to have a copy, an original certified death certificate, as well as a description of the property. And you be sure you talk to your attorneys about that tonight. It's important to ask the attorneys about that because we can't prepare that affidavit. We can't tell you how to prepare it. We can't give you that form. That's legal advice, and we're not allowed to do that. And every case is different. Recorders have different requirements that store-bought. If you decide to do this yourself, store-bought forms don't always meet our requirements. Judge has told you it costs $28 and $8, but if you don't have the right spacing, it's going to cost you an extra $20, so it's going to cost you $48 and $8. So it's really a good idea to talk to an attorney. The $100 you pay tonight, or if you go to the Department on Aging, is a small amount compared to what it'll cost you if you don't do this. So often when a person pays off their mortgage, they say to me, "Where's my deed?" Well, you have your deed. So when are you going to release my mortgage? I don't release your mortgage either. Your bank does that. And they will send you a certificate of release. And if you want to make sure they've done that, you can go online and you can look on my online index to see if that's happened, and then you can call the bank if it hasn't, or you can sign up for a new program called Property Fraud Alert. Protecting your property has always been my number one priority. That's the main reason that only my indexes are online and not my images. You know, it's funny. When I first ran for recorder in 2008, that was one of the things I ran on, that I was never going to put those images online. And it turns out I was really right to be concerned, because now, along with credit card theft, identity theft, and crooks hacking into businesses and companies, they have a new scam, and it's called house stealing or property fraud. The FBI has called house stealing the fastest growing white-collar crime in America. There are several states around Ohio that have been hit hard by it. Ohio hasn't been hit as hard yet, but I decided to initiate this program and be proactive on your behalf. You know, you're going to hear ads on the radio for a company called Home Title Lock. It's similar to LifeLock, and they'll monitor the activity on your property for $9.99 a month. It's a good program for people who don't live in Geauga. But if you live in Geauga, I'm doing it for you for free. Here's what's happening, and there's different variations. The thief will get a hold of your deed. He'll retype it, and he'll make it from you to him, and he'll forge your signature, and he'll often have a notary who's complicit, or somebody who pretends they're a notary and is complicit with it. Then they'll file it, and then they'll take out a home equity line. There's also been cases of angry relatives who do it to other relatives for whatever reason. Unfortunately, criminals have come up with a lot of ingenious ways to steal your property. I personally had a woman come into the office this year, and her father's house was in foreclosure. To make long story short, she forged a release, and she had her friend sign as an officer of a bank, and she recorded it in my office. Needless to say, she's in trouble, but people do this. Now, legally, I don't think you would be responsible if somebody took out the home equity on your home on a forged deed, but it's going to cost you thousands of dollars to clear your title. You're going to have to hire an attorney. You're going to have to go to court. You're probably going to have to hire a handwriting expert, and who knows what else you'll have to do. Sometimes these crooks will sell your house. Sometimes they'll sell, mortgage, or rent unoccupied or foreclosed homes, and they love to target seniors and people who go out of state for the winter. You know, I'm offering this program because to be forewarned is forearmed. But other than fraud, there's other reasons that you want to monitor your property. Mechanics lien. If you have a disagreement with a contractor, they can slap a mechanics lien on your property. A hospital lien. My vendor told me about a case where the mother had to go live with her, and she wasn't getting the hospital bills, so the hospital slapped a lien on the mother's house. Well, she had property fraud alert. She got alert, so she was able to go to the hospital and get it straightened out. This past March, Judge and I were at a veterans affair down at 470 Center, and we were talking about good deeds. And I also mentioned that I was going to get property fraud alert. A gentleman came up to me afterwards, and he said he had a friend with exactly the same name as his. So the one year he wasn't getting his tax bill, and apparently his tax bill wasn't tied to his mortgage, so he knew he didn't get his tax bill. So he went to the treasurer's office, and he said, where's my tax bill? And the treasurer said, well, you sold your house. He said, no, I didn't sell my house. Well, somebody pulled the wrong title when his friend sold his house and sold the wrong house. Fortunately, the two gentlemen knew each other. They were able to get together, go to an attorney, get it straightened out, and it didn't cost him anything. But if he didn't know the other guy and this had happened, and he didn't find out for 10, 20 years, he'd be paying a lot of money to get that fixed. You can keep track of your property. Was your mortgage released by the bank? Did your deed transfer? So these are all things that they'll notify you of if you sign up for Property Fraud Alert. On this brochure, they'll give you 2 ways to sign up. You can either sign up and be notified by email or by the phone. I don't know about you, but I tend to hang up on any numbers that I don't know who they are. So if you sign up for Property Fraud Alert and ask to be notified by phone, you might want to listen to the messages if you do it that way. But and I have a big caveat about this. Property Fraud Alert is not going to prevent fraud or mistakes, but it's going to tell you right away that they've happened so you can do something about it. So take the card. You should have it in your folders. Sign up, call, email, and thank you.
Thank you, Sharon. And by the way, Sharon's done a great job of trying to make sure we get protected from all this potential fraud out there. Couple things we still have this evening: lawyers Robin Stanley, Richard Ivins, Mike Wagner, and James Smolinski. They will consult with you about your personal situation at no cost tonight. They have special rates if you need documents prepared by them, or you can talk to the Bar Association. We're not trying to take any work away from your family lawyer, or go through the Department of Aging. Will help you as well. Why are we doing this? Well, Sharon and I decided that we're from the government and we want to help. I probably haven't heard that before, but yeah, we're from the government and we want to help. The theory is this. We actually teach this now to high school seniors. You really ought to learn this when you're 18 or 20, because this really applies to your whole life, and you may want to pass this on to your children. This should be something you learn, that how you hold your property while you're living decides whether or not it has to come through the probate process. And there's no reason that your family has to incur the time delay and cost of probate if you can do things now that would change the way you own your property to avoid the probate process. That's the whole purpose of this exercise, is to help you do that, because there's no reason to have to come through the court. But if you have to come through the court, we have wonderful clerks. We're here to help you, and we now have a help center. On Thursdays, the probate court now has a help center with an attorney, Mr. Welty, that you can schedule an appointment with. If you actually do have to deal with the probate court in some manner, he can give you some free advice. He cannot represent you, but he can help get you pointed in the right direction. And again, also we have great lawyers here in Geauga County who can help you as well. So with that, if anybody has any questions, we'll be glad to take questions. And if folks want to start seeing the lawyers out there to get their own personal deeds looked at, they're here this evening to help you out. We thank you all for coming. We'll be doing this again, I think, in March. In March will be the next Good Deeds session. So any questions? No? No questions? We thank you all very much. I'll sit up here. Yes, ma'am.
On property deeds, can you do a transfer on death to more than one person?
You can transfer on death to more than one person. You can have contingent transfer on death. I mean, again, you got to talk to the folks here to do that for you, but yes. Yeah. What's I know?
If you have property in a different county,
These rules apply to all 88 counties in the state of Ohio. These rules do not necessarily apply in other states. For example, Florida, Texas, and California are community property states. Talk to lawyers in those states. These rules do not apply. But this applies to any real estate in the state of Ohio. Yes, ma'am.
thank you. If you have a boat, I don't think this is on.
Yeah, that's right.
If you have a boat or an RV, is that in the 65,000 as with the
No,
car, or
no.
that's separate?
Boats and RVs don't count for the 65. The 65
So you
only
should
counts for
title those
automobiles.
too. Okay.
Yeah. The other ones you better have transfer on death to your spouse, or you're going to end up coming to visit.
Yeah.
But you can do all that for $19 a title with the
$19.
Clerk of Court's title division.
Okay, good to know.
I'll ask my question.
Yes.
What qualifies as a simple will? Like, can I write something on a piece of paper, my husband and I sign in front of a notary,
Okay, the state of Ohio prohibits me as judge to practice law. I can answer legal questions, and I will answer it this way, but you may want to just direct that individually to one of the lawyers tonight to make sure it's binding. Generally speaking, a will in Ohio requires to be signed and to have mental capacity to sign the will in front of two witnesses. There is a provision for a handwritten will, but I would suggest you review that with one of the lawyers first. You'd be better off having a will signed in front of two witnesses. Yeah. And there's an attestation language that needs to be in that, signed by those witnesses. All right. You can go to LegalZoom and probably find all these documents. Whether you fill them out correctly is the risk. And when you're talking $100 or, if you're over 60, $25, just live long enough, it's probably better you talk to the lawyer. Sharon, can they still get copies of their deeds?
Did you already order them? Yeah, we did. Okay, I can get it for you. I have them. Is there any other questions?
Well, we thank you all for coming. You're welcome to stick around and talk to the lawyers. I'll sit up here if you have any other personal questions I can answer, but we thank you very much.